Are we on? Are we transmitting? We are? Anyone out there? This is Canada, Radio Free Canada calling. All right, I want to talk about the emergency measures regulation. And I want to look at it in terms of what it tells us about the people who drafted it and what might be the consequences for the people who drafted it. Now, Andrew Coyne, forgive the ruffling here because I'm holding an actual newspaper. Andrew Coyne says in a headline in the Globe and Mail yesterday that the Emergencies Act, 9 days that didn't really shake the world all that much. So Andrew Coyne is one of those people who doesn't think there was much to be concerned about in the Emergency Act or regulations enacted under this legislation. What I want to do is look at the emergency measures regulations and see if there's a reason to be concerned about the state of mind of the people who drafted this. And really, are these the kind of people, if you go on a holiday, would you want them watching your house? Would you want them taking care of your pet? Okay, so let's look at it. Emergencies Measures Regulation, SOR 2022-21, Emergencies Act. This is Canadian legislation and how it's designated. Regulations arise from laws. So a law is passed, like the Emergencies Act, and it allows for like subsidiary laws to be created under it. This is one of them. So the power to make this regulation comes from the Emergencies Act. And this thing says, whereas the Governing Council has, by a proclamation made pursuant to blah, 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 declared that a public emergency exists. And I've written about the way modern parliamentary legislative drafting involves declaring the facts, which now become truth, and then making laws based on those declared facts. Next, and whereas the Governing Council believes on reasonable grounds that the regulation or prohibition of public assemblies in the areas referred to in these regulations are necessary. So the government thinks prohibiting these types of assemblies is necessary. And it doesn't say assemblies by certain people, certain types of people with certain types of income. It just says the assemblies. Okay? Therefore, Her Excellency, the Governor-General and Council, on the recommendation of the Minister of Public Safety and Emergency Preparedness, pursuant to subsection 19.1 of the Emergencies Act, enacts emergency measures regulations. And now here's the interpretive section 1. Now keep in mind the numbering. This is how you interpret legislation. Critical infrastructure means, so the government is declaring what it thinks is critical. Let's see what's in here. A, airports, aerodromes, heliports, harbors, ports, piers, lighthouses, canals, railway stations, railways, tramway lines, bus stations, bus depots, and truck depots. B, infrastructure for the supply of utilities such as water, gas, sanitation, telecommunications. Now keep in mind the language. Infrastructure for the supply of utilities. This doesn't say pipeline that's carrying gas or petroleum to a treatment facility. It has to be infrastructure for the supply of utilities. This is probably natural gas, ready to use natural gas in your homes. Next, international and interprovincial bridges and crossings. D, power regeneration and transmission facilities. E, hospitals and locations where COVID-19 vaccines are administered. Okay, what about other health problems? I guess that doesn't matter. F, trade corridors and international border crossings, including ports of entry, ferry terminals, customs offices, bonded warehouses, and sufferance warehouses. Infrastructure essentielle. The French version. I know why that's in there, because this is an English version. But anyway, what's not in here clearly? Pipelines are not in here. The truckers were clearly not blowing up or blocking pipelines. Not pop lines, pipelines. However, there are certain friends of Mr. Trudeau that don't like pipelines. They, according to this, can keep doing what they're doing because pipelines are not critical infrastructure, and we'll see how that works. Foreign national has the same meaning. That's another definition. Foreign national has the same meaning as in Section 2.1 of the Immigration and Refugee Act. We'll see why that's important below. Protected person, I'll skip peace officer. Protected person has the same meaning as in subsection 95.2 of the Immigration and Refugee Protection Act. Personne protégée. Again, they're slipping French in there for no apparent reason. Now, what is prohibited? A lot of people focus on this. And listen to the language. 2.1. So this is section 2. 1 is up here, definitions, interpretation. This is 2, the prohibition section. A person must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace by A, the serious disruption of the movement of persons or goods, or the serious interference with trade. B, the interference with the functioning of critical infrastructure. Or C, the support of the threat or use of acts of serious violence against persons or property. So this is serious. These are serious, effectively criminal type activities that have been identified here that are harmful to the public and property. This is not regulatory. This is effectively criminal here. Okay. Minor. A person, subsection 2 of subsection 2. A person must not cause a person under the age of 18 years to participate in an assembly referred to in subsection 1. Now this is where it gets interesting. Out of the blue, we're going to talk about people who can enter the country. Prohibition, entry to Canada, foreign national. This is section 3. So you can see the exemption here of section 2 only applies to section 3. It's not referring to section 2. A foreign national must not enter Canada with the intent to participate in or facilitate an assembly referred to in subsection 2.1. Okay, so it does reference 2.1, those prohibited assemblies. But this deals with the foreign national solely in the context of coming into the country. Who is exempt? A person registered as an Indian under the Indian Act. B, a person who has been recognized as a convention refugee. I'll just stop there. C, a person who has been issued a temporary resident permit within the meaning of subsection 24.1 of the Immigration and Refugee Protection Act. I'll just stop there. I'm just giving these as examples. D, a person who seeks to enter Canada for the purpose of making a claim for refugee protection. E, a protected person. F, a person or any person in a class of persons whose presence in Canada as determined by the Minister of Citizenship and Immigration or the Minister of Public Safety and Emergency Preparedness is in the national interest. Now that's interesting. So a friend of the government who's declared is determined. A person who's determined to be here in the national interest can get in here. And that's determined by the Minister of Citizenship and Immigration. There's no criteria here. This is a big loophole. But I'm not even going to talk about that. Let's take an example of let's look at the refugee. Person who seeks to come to Canada for the purpose of making a claim for refugee protection. We only need to use this as an example. This person is exempt from 3.1. All right. So a foreign national must not enter Canada with the intent to participate in or facilitate an assembly referred to in subsection 2.1. Now, when you see intent, that should be a trigger that this has a criminal underpinning, because a criminal act must have two key elements. One is mens rea, that's the mental intent, and then there's actus reus, which is the act. So the intent, there's a criminal intent identified here of wanting to participate in or facilitate an assembly referred to in subsection 2.1. and you go up to 2-1. So 2 is connected here, but only in the case of someone entering the country. So what does this mean if a refugee is exempt? So let's try doing the language here, but in the context of it being exempt. Let's try this. 3.1. A refugee may enter Canada with the intent to participate in or facilitate an assembly referred to in section 2.1. So we can have the intent. So what intent? He can come to Canada and tell the border guards, hi, I'm here with the intent to participate in a public assembly that may reasonably be expected to lead to a breach of the peace by the serious disruption of the movement of persons or goods or the serious interference with trade. Now, question, why would a legislature authorize a person to come to Canada with that kind of intent? And that's what this says. An Indian under the Indian Act, who's a foreign national apparently, can enter Canada with the intent to participate in an assembly that may reasonably be expected to lead to a breach of the peace by the interference with the functioning of critical infrastructure. Why would a legislature authorize that kind of an exemption? Now there's two possibilities. Gross incompetence. So the legislative drafting unit of the Federal Department of Justice or some other relevant federal ministry is manned by hopelessly incompetent lawyers. Or two, this is intended. Why was pipeline left out of here? And why are people permitted to come to Canada with the intent to participate in assemblies expected to lead to a breach of the peace? This is truly a remarkable piece of legislation. So now let's look at what the consequences for the drafters might be. So let's try looking at sedition under the Canadian Criminal Code. Seditious words are words that express seditious intention. Now definitely a lawyer drafted that. Aha, well here we find out what a seditious intention is. Without limiting the generality of the meaning of the expression seditious intention, everyone shall be presumed to have a seditious intention who teaches or advocates or publishes or circulates any writing. Well, was the regulation I just read for a writing? I guess it could be. Was it a writing that advocates the use, without the authority of law, of force as a means of accomplishing a governmental change within Canada? So this would be the trickier part. If you're authorizing people to come to Canada to breach the peace and go after critical infrastructure, are you in fact authorizing, without the authority of law, because you're saying you can breach the peace? So presumably that's without the authority of law. Or someone could argue, of course, that the regulation itself is statutory authorization, but it's so poorly drafted. I think it could be interpreted either way. One as legislative authority to do these acts, or one, you're authorizing people to do illegal acts. So, okay, so sedition is certainly a possible consequence for the drafters of this legislation, this regulation. Let's try another one. High treason. Section 46. Everyone commits high treason who, in Canada, well, we'll skip number one because the Queen is not at issue here other than her health in England. B. Everyone commits high treason who in Canada levies war against Canada or does any act preparatory thereto. Now, attacking infrastructure would be arguably an attack, would be an act preparatory thereto. One can argue that. So I think that's an open question, depending on the facts. C. Assists an enemy at war with Canada or any armed forces against whom Canadian forces are engaged in hostilities, whether or not a state of war exists between Canada and the country's forces they are. So this would depend on who's seeking exemption. You could see possibly someone from, a country in which we're engaged in hostilities of some kind. That's a stretch. I still think the better one is this one. Preparatory acts. Everyone commits treason who, I'm looking at subsection 2, uses force or violence for the purpose of overthrowing the government of Canada. Well, what's violence? Interrupting critical infrastructure, could that be violence? Let's leave that for the lawyers. Without lawful authority, communicates or makes available to an agent of a state other than Canada military or scientific information or a sketch, plan, model. Yeah, I'm not thinking this one's going to apply. I'm not thinking B is going to apply. Let's try C. Conspires with any person to commit high treason or to do anything mentioned in A. Okay. There we get back to this person is going to commit acts of preparatory acts of war. And you are going to help him do that, arguably. All right, 2D. Forms an intention to do anything that is high treason or that is mentioned in paragraph A. Again, I think this is usable, but if you have to use section D, you don't have a really good case. E. Conspires with any person to do anything mentioned in B. As I said, B probably doesn't apply, so I'm just going to leave B aside. Let's try one more. Sabotage. Now, since we're dealing with critical infrastructure, we should look at sabotage under the Criminal Code, section 52(1). Everyone who does a prohibited act for a purpose prejudicial to A, the safety, security, or defense of Canada, or B, the safety or security of the naval, army, or air forces of any state other than Canada that are lawfully present in Canada is guilty of an indictable offense and is liable to imprisonment for a term not exceeding 10 years. So I guess we would have to look at what a preparatory act is, a prohibited act. I'm not going to do that right now. But given that we're dealing with infrastructure, you might want to take a look at that very carefully. I should point out these provisions of the Criminal Code are not generally used anymore, are not referenced, since there are other less perhaps triggering legislation that could be used. So there you go. I just wanted to look over the regulation under the Emergency Act, which has now been apparently withdrawn. And ask yourself, the people who drew up this legislation, and I'm not talking about the financial stuff today, I'm just talking about this regulation and how it's written and what it seems to say, are these people that you might want to be concerned about? Like, how did a regulation like this get created? It's a really good question. So, transmission out. Hopefully I'll be transmitting again soon. God bless.